Thank you so much, Nicole. Hi everyone, my name is BC Matthews and I'm a housing attorney at Bay Area Legal Aid, and I work out of the San Jose office.
Hi everyone, my name is Laura Verwer. I'm also a housing attorney at Bay Area Legal Aid in our San Jose office, which covers Santa Clara County.
Right. Okay, so we're gonna move on to the next slide. We're gonna be saying next slide just so that Nicole knows when to switch over. So we have a lot of ground to cover today. We'll do our best to go over all the topics listed here, from tenants' rights to fair housing protections and an overview of the eviction process and a few more topics. So, and like Nicole mentioned, we'll also allow some time for some Q&A. But before we get into the main presentation, let us tell you a little bit about who we are as a legal firm and what we do. So next slide. So Bay Area Legal Aid is a legal services organization that provides free legal services to eligible low-income residents in the Bay Area. We cover all 7 counties, including Alameda, Contra Costa, Marin, Napa, San Francisco, San Mateo, and Santa Clara. And in the Santa Clara County office, our 8 practice areas include the housing preservation and homelessness prevention. This unit assists clients in addressing landlord-tenant matters, defending against illegal evictions, asserting their rights under fair housing laws, and combating discriminatory housing practices. A lot of those topics, again, we'll cover today. And we also assist clients with subsidized housing issues by helping them with preserving their Section 8 vouchers or their tax credit units. The Immigration Unit provides services to immigrant survivors of domestic violence, such as, and such services include VAWA assault petitions and U-Visa petitions, temporary restraining orders, and other services for survivors in conjunction with our domestic violence prevention practice. Our Health Consumer Center assists clients with navigating services from public and private health insurance programs, such as Medi-Cal, Medicare, in-home supportive services, and other county health programs. And our Veterans Projects assists veterans facing issues related to their veterans benefits, including service and non-service connected disability benefits and discharge issues. They also assist clients who are facing issues related to our other practice areas.
And we also have a domestic violence and sexual assault prevention unit that assists clients with obtaining temporary restraining orders, divorces, child and spousal support orders, safe custody, and visitation orders. We also have an economic justice unit that assists clients with obtaining access to or addressing any wrongful terminations or denials relating to their income support programs, such as SSI, SSDI, general assistance, food stamps, CalWorks, and more. And then we also have a consumer law unit, and attorneys in this practice area assist with a variety of consumer-related issues, including fair credit reporting, fair debt collection practices, and bankruptcy counseling. We also have a youth justice project, and this is kind of a general practice area that assists clients in areas including foster care, health access, SSI, education, housing, and homeless youth services. Next slide, please. Unfortunately, we may only provide services to eligible clients. The eligibility requirements include that the client must live in one of our 7 counties that we practice in. So Alameda, Contra Costa, Napa, Marin, Santa Clara, San Francisco, or San Mateo. They also need to be a citizen or eligible immigrant. We can provide services to U.S. citizens or certain family members of a citizen with a pending application for permanent residency, those with a green card, or refugees or asylees. Any immigrant who is a victim of domestic violence, sexual assault, human trafficking, or other violent crime. And we can also represent eligible children in public benefits or domestic violence matters, even if their parents aren't eligible. We also have a financial requirement. So gross income generally has to be under 200% of the federal poverty line, except for our health work. So anything that is in our health consumer center, there is no income requirement, and they can be above the 200% federal poverty line. And this also, there is a exception, limited exception for our veterans. Our veterans practice area generally can go above the 200% federal poverty line for assistance in our office. Next slide, please. So these are the ways to access our services. There's the legal advice line, that's for all practice areas. They can be reached at 1-800-551-5554. They are open Monday through Thursday from 9:30 a.m. to 1 p.m. And they'll go over the eligibility questions. And even if someone isn't eligible for services, they can still provide information over the phone. And then our Health Consumer Center, the phone number is 1-855-698-7285. And they are open Monday through Friday from 9 a.m. until 5 p.m. Thank you. So we'll get started with the first topic, tenant rights. First, we'll go over rental qualifications. So generally, landlords do require certain rental qualifications before renting a unit to a tenant. Each landlord is different. There will be different qualifications depending on who the landlord is. Some landlords are very lenient, while others may have more strict criteria. Landlords do generally request for names of employers, previous landlords, and also references. And landlords may also require applicants to pay a fee so that the landlord can obtain a credit report. Beginning in 1998, the fee was limited to $30 and can increase with the Consumer Price Index. So currently, the limit is around $50, and an applicant cannot pay more than what that limit is for the application fee. Landlords may also choose not to accept a tenant depending on their credit score, or if they do have an eviction on their record, which can pop up in their credit report. But if a tenant's credit score may not be great, they can demonstrate proof of their ability to pay rent based on their past rental payment history and also their proof of their income. Next slide, please. So now we'll talk a little bit about criminal history. Effective January 1st of this year, there's new California regulations interpreting the anti-discrimination laws that prohibit landlords from considering certain types of criminal history. And this includes arrests that did not lead to a conviction, participation in a pre-trial or post-trial diversion program, any record of a conviction that has been sealed by the court. So this means if a case has been dismissed or if a case has been expunged, or any conviction that came from the juvenile justice system. These new regulations also include a prohibition on landlords to implement these blanket bans on all applicants with criminal histories. So landlords must look at the individual circumstances involving a conviction to decide whether it is directly related to an applicant's ability to be a good tenant. Next slide, please. So just to summarize, housing providers may not access criminal or civil records that are older than 7 years. They cannot, again, ask for or use any information about arrests that did not lead to a conviction. They can't have any blanket no felons policy or otherwise exclude all individuals with a criminal record. So for example, there may be Craigslist ads that state no felonies. Just did a search the other day to see whether You could still find these. Unfortunately, you can, but these are unlawful, and these do violate the new regulations. Also, a housing provider, a landlord, cannot ask or use any information about any juvenile adjudications. They can't ask for or use any information about a conviction that has been expunged. So again, if the record has been sealed, if the case has been dismissed, a landlord cannot use or even ask for that type of information. A landlord cannot also deny someone whose qualifications are a function of a disability where they would be entitled to a reasonable accommodation. So this includes, for example, a prospective applicant or a tenant that has a mental health impairment that led to a conviction of disorderly conduct, for example. If the applicant has been treated for their mental health impairment, where they would no longer be an issue, their mental health related to the conviction, then the tenant should be able to have a reasonable accommodation so that conviction is not negatively considered on their application. And then also, a landlord can't deny someone whose qualifications are related to a history of domestic violence. In federally subsidized housing, there's the Violence Against Women Act, which provides protections to tenants in federal housing programs. So if the conviction or criminal history is related to an act of domestic violence, then that shouldn't prohibit that applicant from being considered and would be protected under VAWA. Next slide. So here's just a couple hypos. The first one is a landlord posts an advertisement for an available one-bedroom unit. The advertisement specifically states no individuals with criminal records. Is this permissible? Just a yes or no. And then the next one is a landlord posts an advertisement for an available one-bedroom unit. The advertisement specifically states no individuals with prior felonies. Is this permissible? Take a couple minutes for the poll.
While we're waiting for people to answer and I'm seeing results come in, I just want to reiterate that we will be sharing all of the slides, all of the material that Bessie and Laura are covering today, because I've received quite a few questions in the chat about that. So we will be sharing it as quickly as possible after the training.
Thank you. And then I also see there's a quick question that we can answer while the poll is being answered. There's a question about, isn't there a limit to the time you can request a reasonable accommodation? And there isn't a limit to the time you can request a reasonable accommodation. So a reasonable accommodation can be made at any time. Even, for example, if there was an eviction where a person should be entitled to a reasonable accommodation, even after the eviction judgment has occurred, someone can make a request for a reasonable accommodation. So there is absolutely no time limit. And we'll talk about reasonable accommodations later on.
I'm going to go ahead and end the poll now. I see a couple more, but we've reached 61%, so that's pretty good critical mass.
Okay, so it looks like majority said no. For the first one, 91% said no and 9% said yes. So the first one, where the advertisement states no individual with criminal records, this is not permissible. This is considered a blanket ban where a landlord does have to take an individualized assessment and cannot just implement a blanket ban on criminal records. And the second one, kind of a trick question, but is similar. So this one is the advertisement specifically states no individuals with prior felonies. Is this permissible? So majority of you said no, 83%, and then 17% said yes, it is permissible. So actually this is not permissible. This is another example of a blanket ban. And even if it is for a more serious crime, like a felony, this is impermissible, and a landlord cannot implement a blanket ban even if it is considering a more serious type of conviction. Next slide, nice. So moving on to understanding leases. So a lease agreement is a rental agreement that basically creates the terms and conditions around a tenant's right to use and possess the landlord's rental unit. Lease agreements can be oral or in writing, even though it's strongly recommended that the lease agreements are in writing. And the reason that it's recommended that lease agreements are in writing is so that both landlords and tenants can look back on the written terms of the lease agreement and know what those terms are and can reference what the agreement was. So there are a few types of tenancies. There's fixed term tenancies, and these are tenancies that are set for a period of time. So for example, 6 months or 1 year or 2 years. And then there's also periodic tenancies. So periodic tenancies do not have an expiration date and can last until the tenancy is terminated upon proper notice by either party, by either tenant or the landlord. So for example, these include month-to-month tenancies. So where the type of tenancy is important is when the parties do want to terminate the tenancy. So for a periodic tenancy, like a month-to-month tenancy, if someone has been living in the unit for less than a year, then they can, the landlord can terminate the tenancy upon 30 days notice, as long as that notice is proper and complies with all other legal requirements, including just cause if applicable. And on that note, on the flip side, a tenant can also terminate the tenancy upon giving 30 days notice to the landlord. If the tenant has resided in the unit for longer than 1 year, then a tenant is generally entitled to a 60-day notice to terminate that periodic month-to-month tenancy. So with the fixed term tenancy, the tenancy can only be terminated at the end of the fixed period. So if there has been, unless there's been any issues like serious lease violations, like non-payment of rent or nuisance, then a landlord can serve a notice to try to terminate that tenancy earlier, making sure they cite those reasons. But otherwise, a tenant would be entitled to remain in the unit for the period of their lease. If a tenant wanted to leave before the lease term expired, they would be responsible for the rent for the remainder of their lease unless they can find another tenant to take over that the landlord agrees to, or if there's a mutual termination between the landlord and the tenant. If the tenant does leave, the landlord does have an obligation and a duty to try to mitigate their damages and find a replacement tenant, but that tenant could be responsible for the amount of rent until the landlord does find another tenant to take over that rental unit. Some key terms in lease agreements include, the address of the rental unit, the amount of rent, who the rent is supposed to be paid to, and where it's supposed to be paid, the amount of the security deposit. In California, the security deposit is limited to 2 months of rent for unfurnished units and 3 months of rent if the unit is furnished. Other important terms include whether pets are allowed or not, whether there's an occupancy limit, attorney's fees if the matter does get into a legal dispute like an unlawful detainer action, also known as an eviction, and then utilities, who's responsible for paying utilities. Next slide, please.
Can I have a question before we go to the next slide, or you are collecting the questions at the end?
Generally, we're waiting for questions before the break.
Okay.
If you want to take a note, or if you want to put it in the chat,
Okay.
we can see if we can try to answer it if it's quick.
Thank you so much.
Mm-hmm. So going on to habitability. So a landlord has a duty to provide a habitable unit. And what does habitability mean? It basically means that the unit is fit for occupation by a human, and that it does substantially comply with all local and state building and health codes that materially affect a tenant's health and safety. So before a landlord rents a unit, they do have to make sure that the unit is fit and habitable to live in. During the tenancy, a landlord has a duty, it's called the implied warranty of habitability. They have a duty to repair any problems that make the rental unit unfit to live in or uninhabitable. Inhabitable, I think there's a little typo there, sorry. So what makes a unit habitable? Making a unit habitable means a landlord has effective waterproofing or weather protection for the roof and exterior walls, including making sure there's no unbroken windows or doors. All plumbing facilities have to be in good working order. There has to be hot and cold running water, has to be connected to a sewage disposal system. The heating facilities have to be in good working order. The electrical system, lighting, wiring, all of that has to be in good working order. It has to be clean and sanitary, so it has to be free from debris, garbage, rodents, vermin. There has to be adequate trash receptacles, and then the floors, stairways, and railings do have to be in good working order. Next slide, please. So what should a tenant do if repairs are needed or if the unit becomes inhabitable? So tenants should give notice to their landlord immediately, and it's recommended for the notice to be in writing, and for the tenant to keep a copy of whatever notice they provide to their landlord. If the tenant was part of the reason or substantially caused the unlivable condition, then the tenant may be responsible for the cost of the repairs. It's also important to know that tenants may be responsible if they substantially interfere with the landlord's ability to conduct repairs. So for example, if the landlord is trying to gain access to the unit to make the repairs and a tenant is refusing the landlord access, that could be an issue where the tenant may be responsible if the condition worsens. So what are some remedies for the tenant if the landlord doesn't conduct repairs? So first, a tenant has a right to contact code enforcement. If repairs are required and the landlord does not conduct the repairs after given a reasonable amount of time after notice of the need for repairs, a tenant does have a right to contact code enforcement. So code enforcement is a government agency that can conduct investigations and mandate that the landlord complete the repairs. There is a risk that if the habitability issues are severe, code enforcement may what's called red tag the property and require the unit to be vacated. So this would place the tenant in a situation where they may have to look for alternative housing. So it's best to advise tenants of this risk before contacting code enforcement. On the other hand, landlords may be responsible for paying relocation assistance if the tenant is required to vacate. In practice, there may be issues with tenants being able to receive that relocation assistance, and unfortunately may have to go through small claims or some other legal proceedings to try and recoup that relocation assistance that they are owed. Another remedy that a tenant can use is repair and deduct. So this remedy allows a tenant to deduct money from their rent to pay for the repairs for the defects in the unit if the repairs wouldn't cost more than 1 month's rent. So that is a big thing. The repairs can't be more than 1 month's worth of the tenant's rent. And also a tenant can't use this remedy more than once in a 12-month period. Also the tenant or the household, for example, pets, must not have caused the defects that require the repair. The tenant must inform the landlord, preferably in writing, that the repairs are needed, and the tenant must give reasonable time for the landlord to conduct these repairs. Reasonable time depends on what the issue is. Generally, reasonable can mean 30 days. Other times, for example, if the heater is broken in the wintertime, where it's freezing, then a shorter period may be considered reasonable, for example, a few days. So if the landlord doesn't conduct the repairs in that reasonable amount of time, then a tenant could conduct the repairs themselves and deduct that from the rent. The risk is that the defect must be serious enough to justify using this defense. If a tenant deducts the cost of the repairs from the rent, the landlord could serve a non-payment of rent notice upon the tenant, and the tenant risks an eviction action being filed against them if they don't pay. And it's really important, because of the risk of the eviction, that the tenant clearly documents the defects by taking photos of the defects, and also documents the notice given to the landlord, and also retains any copies of the receipts for the amount and the price of the repairs that they paid. So because of the risk of eviction, it's not, we don't advise this remedy, just because there are certain steps that the tenant needs to take, and then if the tenant does not take those steps properly, they could be at risk of eviction. Another defense, or another remedy to habitability, is abandonment. So it's similar to repair and deduct, except that if after providing notice and a reasonable time for the landlord to make the repairs, the landlord doesn't conduct the repairs, then the tenant could abandon the unit, and they wouldn't be responsible for the rent for the remaining of their lease term. Risk with this remedy is, again, the defect must affect the health and safety of the unit, of the tenants in the unit, and it has to be serious enough to justify using this remedy. If the tenant does abandon the unit, again, they should document the need for repairs well, with pictures, photos, video, and also document the notice given to the landlord, because a landlord could possibly sue and collect for any unpaid rent that the landlord believes that is owed, and a tenant would have to be able to prove that they were right in abandoning the unit due to the habitability issues in the unit. Another remedy is withholding rent. So this is another option that a tenant may have if there are serious defects in the unit that affect habitability of the unit. The defects must be substantial and serious to threaten the tenant's health and safety. The tenant must not have caused the defects, or the household must not have caused the defects in the unit. And the tenant must inform the landlord, preferably in writing, and give reasonable time for the landlord to make repairs. If the landlord doesn't make the repairs, then the tenant can withhold some or all of the rent. Tenants should save the withheld rent and not spend it, because the tenant may have to pay the landlord some or all of the withheld rent. So the risks include that the defects may not be serious enough to threaten the health or safety. If the tenant withholds the rent, the landlord may give the tenant a notice, a 3-day notice to pay rent or quit. The tenant refuses, the landlord can file an eviction action, and the tenant would have to prove that the landlord violated the implied warranty of habitability. So the tenant, again, should clearly document the defects, the notice provided to the landlord. If they win, if there is an eviction action filed in court where a tenant asserts this defense, if they win, the landlord will be ordered to make repairs, but the tenant may also be ordered to pay a reasonable rent, so it could be a reduction that the judge orders. And this rent ordinarily has to be paid within 5 days and from the date of the court judgment. If the rent is not paid within that time frame, then the judgment could go to the landlord, and the tenant may be evicted. So it is a risk to use this defense. That's why it's really, really important for tenants to document any defects and the notice given to the landlord, especially how much time they gave the landlord to make the repairs. And then lastly, a tenant can file a lawsuit for breach of implied warranty of habitability in or construction eviction if they do end up leaving the unit. If the damages are less than $10,000, then they can file a small claims action in small claims court. If the damages are above $10,000, then they would have to file a lawsuit in superior court. Next slide, please. So here are some of the best practices. The first is just the duty of good faith and fair dealing. Both parties, the landlord and tenant, do have an obligation to engage with each other in good faith and fairly. For example, a landlord cannot fail to make repairs simply because a tenant has paid rent late in the past. Can't do anything out of spite, can't be petty. Additionally, a tenant cannot pay rent late on purpose simply because they don't like the way a landlord may have handled a certain situation. Another best practice is for tenants to inspect the unit, and this goes for both upon moving in and upon moving out. So before moving in, the tenant should inspect the unit thoroughly, make note of any need for repairs, and let the landlord know in writing what repairs are needed. Additionally, upon moving out, and also upon moving in, they should take pictures of everything to document how the unit was when they moved in, so they have a reference when they do move out of the unit. And then when moving out, tenants should also, again, inspect the unit and document the condition of the unit as they left it so that they can obtain their security deposit back. So landlords, upon moving out, will do close inspections of the unit to determine how much of the security deposit they can retain. For security deposits, they can only deduct beyond ordinary wear and tear if there's any needed issues for repairs. And so for tenants to ensure that they receive their entire security deposit back, they should clean the unit to how it was when they moved in, and also document what it looks like upon moving out so that they can ensure that they retain their security deposit. Another good practice is to communicate. It's best to communicate to try and avoid or resolve any issues with their landlord. It's best for communication to be in writing, preferably an email, text message, anything with a timestamp is always good, just so that a tenant can prove in court if needed when notice was provided, what day, include dates on any written communications to help build that paper trail if they do need it in the future. And then lastly, to pay rent on time, it's best to pay rent either by money order or with a check, any way to document and keep a receipt. If a tenant is paying cash, they should obtain a receipt every time and keep it safe for their records. Next slide. So this is a hypo. So Tammy, tenant, has a rental agreement and where she agrees to pay $1,000 in rent. A year into her tenancy, she has a roach infestation in her unit. She verbally told her landlord. The landlord immediately contacted pest control. Pest control came and eradicated the roaches. About 6 months later, Tammy notices roaches and ants in her kitchen. She does not tell her landlord and withholds rent for the month. So what best practices should Tammy have done? And then also true or false, if Tammy's landlord files an eviction action, should Tammy assert habitability as a defense? just while we're waiting, I'll try to answer some of the questions. We'll deal with some COVID-related issues later on. And also reasonable accommodations about no pet policies. We'll get to that later in the presentation. How much is reasonable amount of time for landlords to make necessary repairs? So it does depend on what repair is being made. Generally, 30 days is a reasonable amount of time. But again, that could depend depending on what repair is needed to make that reasonable analysis. I'm going to the poll results. So for number 1, what best practices should Tammy have done? 1, provide a notice in writing to inform landlord after habitability issues started again. 3, take pictures of the habitability issues, or 4, all of the above. So the answer is all of the above. Definitely Tammy should provide notice in writing and should have informed her landlord after the habitability issue started again. Because if the landlord doesn't know what the issue is, then there's no way for the landlord to address it. And then also definitely take pictures of the habitability issue just to document and be able to use that as a defense later on if needed. Number 2 is a true or false question. If Tammy's landlord files an eviction action, Tammy should assert habitability as defense. 66% said true, 34% said false. So the answer is true. Whether or not this would be a strong habitability defense is questionable, but as we'll get to later on in the presentation for the eviction process overview, tenants should always assert any defense that they have. If there's even an inkling of a chance that it applies, they should definitely assert it. If they don't assert it in their answer, responsive pleading, then tenant loses that ability to assert it later. And it's also good just for negotiating points for a tenant. So definitely she should assert it.
Okay, we'll now turn into fair housing laws. Let's go on to the next slide. Okay, so there are both federal and state laws that prohibit discrimination in the housing context. Each of these laws provide for protection from discrimination. Some of these statutes are broader than others and provide for larger protections, especially when it comes to protected classes, which we will discuss in the next slide. So under fair housing, under the federal laws, we have Fair Housing Act, Fair Housing Amendments Act, Section 504 of the Rehabilitation Act, Americans with Disability Act. And under state law, we have the Federal Employment and Housing Act, the Unruh Civil Rights Act. And the purpose of fair housing laws is to prevent discrimination in housing by making it illegal to disadvantage someone who is renting, buying, or occupying a home because of that person's membership in a protected class. Next slide, please. So the protected classes here under federal law include race, color, religion, sex, familial status, national origin, physical or mental disability. And then under California law includes all of the protected classes that are covered under the federal law, but also provides for additional protections to the following classes. So marital status, ancestry, sexual orientation or gender expression identity, source of income, or medical condition or genetic information. I'm just going to define quickly a few of these terms under California law. So under California law, gender means sex and includes a person's gender identity and gender expression. And gender expression means a person's gender-related appearance and behavior, whether or not stereotypically associated with the person's assigned sex at birth. And sexual orientation means heterosexuality, homosexuality, and bisexuality. Medical condition means either of the following: any health impairment related to or associated with a diagnosis of cancer or a record or a history of cancer. Genetic characteristics. For purposes of the section, genetic characteristics means either of the following: so any scientifically or medically identifiable gene or chromosome. I'm just trying to provide you with definitions just so that it's clear. Or a combination or alteration thereof that is known to be a cause of a disease or disorder or person in that person or that person's offspring, or that is determined to be associated with a statistically increased risk of development of a disease or disorder, and that is presently not associated with any symptoms of any disease or disorder. And then there's a definition here regarding inherited characteristics that may derive from the person's, from the individual or family member that are known to be a cause of a disease or disorder in a person or that person's offspring, or that are determined to be associated with a statistically increased risk of development of a disease or disorder, and that are presently not associated with any symptoms or any disease or disorder. So again, that's just the legal definition of the genetic information. Next slide, please. So what conducts are prohibited? Intentional discrimination is prohibited, and this means treating a member of a protected class or a person associated with them differently. For example, not renting to a person because he or she has a disability or because of their membership in any other protected class. Disparate impact is another prohibited conduct, and unlike intentional discrimination, disparate impacts describes a situation where at first glance it doesn't seem like the action is discriminatory, but it does have a discriminatory effect. So for example, where say a developer is constructing a building and puts out applications for new properties, and as part of the application to rent, the developer says that each person needs to be gainfully employed as a measure to ensure that residents could afford to pay. This policy would have a discriminatory effect on people with disabilities because they more likely are to be unemployed and receive income through other means rather than unemployment. And sexual harassment is another prohibited conduct. And so under sexual harassment, there's two kinds: the hostile environment and quid pro quo. Hostile environment really means where there's unwanted sexual advances. And quid pro quo is a Latin term for this, for that. For example, where the landlord might be requiring sexual favors for housing privileges. Also, discrimination against domestic violence survivors is prohibited. For example, where a landlord is trying to evict a tenant based on calls for emergency assistance. These can have a disproportionate effect on domestic violence survivors and can cause a chilling effect on DV survivors who are seeking emergency assistance or aid. So persons who feel discriminated against either intentionally or through disparate impact, or who are experiencing sexual harassment, may file a complaint with HUD or DFEH, Department of Fair Housing and Employment. Or you can feel free to refer them to us, and we may be able to assist them if they're eligible for our services. Next slide, please. So requesting reasonable accommodation. A reasonable accommodation is a change in rule, policy, practice, or services that is necessary to allow a person with a disability the equal opportunity to use and enjoy the dwelling. And disability means a mental or a physical impairment that substantially limits one or more life activities. And where the person has a history of that impairment or is regarded as having such an impairment. Now, California law only requires that the impairment limit a life activity. And so life activity could mean walking or working or just taking care of oneself. Next slide, please. And so we'll talk about how to request an RA. We generally refer to reasonable accommodations as RAs. So an RA must be requested verbally or in writing. Again, like Lara mentioned earlier, we always strongly advise clients to make sure that all of their communications with landlords is in writing. And a reasonable accommodation must have what's called a nexus between the disability and the requested accommodation. So this means that the accommodation that is requested must be connected to the disability and must be necessary for the person with a disability to use and enjoy their housing. For example, it would be challenging to prove a nexus between someone with a hearing impairment to request an assigned parking space that's close to their apartment, because there's really no direct connection between, again, hearing impairment and the need for an assigned parking space. But on the other hand, a person with a mobility impairment that makes it difficult for them to walk is able to make that connection between the disability and the requested accommodation. So if a housing provider believes that the requested accommodation is not reasonable, then the housing provider and the resident are supposed to engage in an interactive dialogue to get more information about the disability related need, and so that they can find some type of reasonable alternative. And it may be considered discriminatory if a housing provider denies a reasonable accommodation. And if the housing provider denies a resident an RA, the resident has the ability to seek enforcement of fair housing laws through a HUD complaint or a DFEH complaint. And just, again, best practices, make sure the request is in writing. And it's always best to attach a verification from a knowledgeable professional. So for instance, a doctor or a clinician. And it's important to make sure that in that verification, they again note that the impairment substantially limits a major life activity, and they should note the need for the accommodation requested. Next slide, please. Okay. So here, these are just a couple of examples. The first example here is a parking space example. So a housing provider has unassigned parking spaces for residents on a first come, first served basis. And a tenant has a mobility impairment and is substantially limited by her ability to walk. She requests an assigned parking space close to the entrance of her unit, and the housing provider, in this case, must make an exception to its policy of not providing assigned parking spaces to accommodate this resident, again, because of the mobility impairment. The second example here is a no pets policy. We had a question earlier, so hopefully this will answer that question. So for instance, a housing provider has a no pets policy, and the tenant with a hearing impairment requests that he be allowed to keep a dog as a reasonable accommodation. The dog is an assistance animal, that alerts the tenant to sounds, including knocks on the door, and the sounding of smoke detectors. The housing provider here must make an exception to its no pet policy, allow for that service animal. Also, where a tenant maybe suffers from depression and uses an emotional support animal to cope with their symptoms of depression, the housing provider must make an exception to its no pet policy. Next slide, please. So here we have a couple of hypos. True or false? One, someone with a mobility impairment can request a parking spot closer to their unit as a reasonable accommodation. Two, someone who has a hearing impairment can request a parking spot closer to their unit as a reasonable accommodation. True or false? Three, a person with a mental health impairment received a notice of lease violation due to symptoms of his or her disability. This person can request that the notice be withdrawn as a reasonable accommodation. Okay, so it looks like everyone answered true for number one, and yes, the answer is true. I'm glad to see that everyone got that correct. Someone with a mobility impairment can request a parking spot closer to the unit, again, because the disability is directly related to the reasonable accommodation that's requested. For two, the answer is false. Looks like 73% got that correct. The other 27 said true. The reason this is not true is because the disability here is a hearing impairment, and the request that is being made is for a parking spot. So if there is no direct nexus between the disability and the accommodation that's been requested, there has to be that link for it to be reasonable and for it to be granted. Three, most people will answer true. The answer is true. Because the notice that the person received here was due to their symptoms, they can and should request a reasonable accommodation for the notice to be withdrawn. Okay. Oops. All right, so we're gonna move along here. Laura.
Now we're going to get into source of income discrimination. Next slide, please. So, source of income, as Casey mentioned, is now a protected class in California. So a landlord cannot discriminate against an applicant or a tenant because of their source of income. And cannot refuse to accept someone with a Section 8 voucher, for example, or someone with a HUD-VASH voucher, for example. It redefines what source of income means, and so it does include the federal subsidized programs. And it is, so if a landlord does discriminate against a tenant based on their source of income, that tenant does have a right to file a discrimination complaint with California's Department of Fair Employment and Housing, not quite HUD, United States Department of Housing and Urban Development, because again, it's only a protected class under California law and not federal law. It is important to note that even though a landlord is prohibited from denying someone simply because they do have a Section 8 voucher or some subsidized subsidy, a housing subsidy, a tenant still has to meet the landlord's other criteria. So for example, if a tenant does have on their credit report an eviction on the record, or credit that doesn't meet the landlord's requirements, then a landlord could still deny that tenant based off of their lawful criteria. Next slide, please. So now we'll talk about the Immigrant Tenant Protection Act, also known as AB 291. So AB 291 made sure that landlords are prohibited from asking a tenant about their immigration or citizenship status. Again, this is unless it's necessary to apply with a federal government program or other legal obligations. So some in federal subsidized housing, a housing program may require to ask information about citizenship status or immigration status. So this would not apply in those situations. But landlords are also prohibited from requiring a tenant or prospective tenant from making a statement, representation, or certification about their immigration or citizenship status. And a landlord cannot disclose any information relating to the immigration or citizenship status for the purpose of retaliating against a tenant, harassing a tenant, trying to intimidate a tenant, or influencing a tenant to vacate, or trying to recover possession of the unit. Next slide, please. So landlords are also prohibited from evicting tenants based on their immigration status. If the landlord does try to evict a tenant based on their immigration status, a tenant can use that as an affirmative defense in an unlawful detainer action. It is a rebuttable presumption that a tenant or occupant has established an affirmative defense. If the landlord did both of the following, which is approve the tenant to take possession before filing the unlawful detainer or eviction action, and included in the unlawful detainer claim based on the tenant's failure to provide a valid social security number, or that the previously approved tenant failed to provide required information to obtain a consumer credit report, or that the failure at any time of a previously approved tenant to provide a form of identification deemed acceptable by the landlord. So now we'll get to hypo. So Tammy, tenant, rents a studio from landlord. She has a green card. During her tenancy, Tammy's studio required several repairs. She provided written notice to her landlord, but her landlord did not respond immediately. After 3 weeks, her landlord stated that he would get a repair person out to her unit. After reminding her landlord no one came to Tammy's unit for over a month, Tammy contacted code enforcement. Code enforcement did an investigation and ordered Tammy's landlord to make repairs. And Tammy's landlord gets upset and accuses Tammy of being undocumented and tells her that she needs to vacate immediately and, quote, go back to her country. Landlord sends Tammy a text message threatening to contact ICE. So true or false, landlord engaged in unlawful retaliation. So yay, 100% said true, and that is true. So unfortunately, in this situation, landlord did engage in unlawful retaliation. A landlord cannot retaliate first, even if immigration status wasn't part of this. A landlord can't retaliate against her for contacting code enforcement, but also can't threaten to disclose immigration status. And here, even though she is a lawful permanent resident, The landlord did perceive what her immigration status was, and threatening to disclose any perceived immigration status is unlawful as well. Now we'll talk about the apartment rent ordinance. So this is an ordinance in San Jose. The ARO covers most apartments built before September 7th, 1979. Under the ARO, it limits covered units to a 5% annual rent increase. And landlords may only increase the rent once every 12 months, provided that the tenant is given proper written notice. So landlords of covered units are required to post city-approved notices in a conspicuous place in each of the buildings where there's at least one or more ARO units. Under the ARO, rent can only be increased for the following reasons. So it's either the annual allowable rent increase, again, that's limited to 5%. It's where there's vacancy decontrol. So this is when a unit covered by the ARO is vacated as a result of a tenant voluntarily leaving or for a proper termination. Then the landlord may set the new initial rent for the new tenant at their discretion. Also, with fair return rent adjustments. So the City of San Jose may authorize a special fair return rent adjustment if the landlord is able to demonstrate that their current year net operating income was lower than the base year net operating income. It's also adjusted for inflation. Where there's a specified capital improvement adjustment in addition to rent. So the city may authorize a specific capital improvement pass through to tenants. A list of these improvements can be found in the regulations. The improvements must have to be completed within 12 months prior to the petition being filed. And these pass-throughs are capped at 3% of the rent. And also where there's one-time payments for new additional housing services. So a tenant may file a petition with their landlord for a one-time payment of increase in security deposit for providing a new service or a service that was expressly prohibited by a written rental agreement. And then with voucher holders, rent increases are determined by program guidelines. Next slide, please. So there are covered units versus units that are not covered. Generally covered properties include apartments with 3 or more units that were built or rented on before September 7th, 1979. This has to do with the state law based on the Costa-Hawkins. So units with rent that is fully or partially paid for by a government subsidy where the unit was built or rented on or before 1979. And then the buildings that are not covered are the units that were built after September 7th, 1979, duplexes, single family condos, townhouses, and also single family homes. There's a useful map from the City of San Jose where you can type in an address and see whether or not that unit is a rent stabilized unit covered under the ARO. Another way to check whether a unit is covered under the ARO is to contact the City of San Jose's Housing Department. Next slide, please. So now we'll briefly talk about the Ellis Act, the Ellis Act ordinance. So the Ellis Act ordinance applies when an owner or developer is planning to demolish or remove apartments from the rental market. So this ordinance applies to apartments that have 3 or more units that were either built before 1979 and are rent stabilized or built after 1979. Even if they're not rent stabilized, the different requirements are if the building is subject to the ARO or not. If it is subject to the ARO, then there are certain amount of units that will be subject to the ARO once if rental units are built in that same property. once demolished. The main thing to note about the Ellis Act ordinance is the notice requirements. So a landlord or owner is required to give a tenant 120 days notice of the intent to remove or withdraw the unit from the rental market or intend to demolish. So tenants who are elderly, disabled, or who have school-age children may be entitled to an extension of when that unit is actually withdrawn from the rental market. Another important thing to note about the Ellis Act is relocation assistance. So tenants who are given the 120-day notice are entitled to relocation assistance, and certain tenants are entitled to additional qualified assistance if they are able to demonstrate that they are low income or elderly or disabled or have school-age children. If they are able to demonstrate that, then they are entitled to additional relocation above the base relocation assistance. And we'll move on to next slide.
Okay, I promise we're going to take a break soon, but we just want to cover a couple more topics before we take a few questions and then a break. Okay, so the next topic here is San Jose Tenant Protection Ordinance. Okay. So we just call it the TPO. The TPO went into effect on January 16, 2017, and protections are applied to all new and existing tenants. It provides substantive requirements for evicting tenants, for tenants who live in certain covered apartments, which are listed below. This ordinance eliminates no-cause notices to vacate, so yay for that. But again, it only applies to those covered units. And all terminations of tenancy must be based on at least one of 13 just cause terminations, which we will discuss in the next slide. But those covered units include rent stabilized units, which means rental units that are subject to rent stabilization under the AR rule, which Laura just discussed. Rental units in any multiple dwelling except permitted hotels and motels. Guest rooms in any guest house, and unpermitted units. So unpermitted units or dwellings means a structure or parts of a structure that are being rented as a home, residence, or a sleeping place where the use is not authorized, permitted, or otherwise approved by the city. Next slide. Okay, so what are just cause terminations? There are what's known as at-fault just cause terminations and no-fault just cause terminations. At-fault just cause terminations, this means that the tenant here is at fault, and they include non-payment of rent, a material or habitual lease violation, substantial damage to the unit, refusal to agree to to agree to a similar or new rental agreement, nuisance behavior, refusing access to the unit, or where there's an unapproved holdover of a subtenant. And then no fault just causes include, this is again where the tenant is not at fault, but the landlord still wants to move forward with an eviction. That includes where there's a substantial rehabilitation of the unit, a removal of the unit under the Ellis Act. The owner wants to move into the unit where there's an order to vacate by the city, or where the tenant has to vacate because the unit is an unpermitted unit. Where the landlord is trying to evict a tenant for no fault just cause, relocation assistance must be provided to the tenant. And landlords must also provide the tenant with the right to return to the unit in certain circumstances. Okay, next slide, please. Recently, I guess it was effective June 15, 2018, the TPO also included an anti-retaliation, including immigration status provision. And under this provision, landlords may not disclose or threaten to disclose tenants' immigration or citizenship status to authorities for the intent of retaliation. A landlord may not disclose or threaten to disclose landlord may not threaten to bring an action to recover possession. A landlord may not cause the tenant to quit the rental unit involuntarily. A landlord may not serve any notice to quit or a notice of termination. Reduce any housing services, report or threaten to report the tenant, a tenant's household, or any individuals that the landlord knows to be associated with the tenant to the immigration authorities, or even increase the rent where the landlord's intent is retaliation against the tenant because the tenant asserted their rights or try to exercise their rights under the TPO. Next slide, please. So we will do a quick hypo here. Tammy tenant lives in a 2-bedroom apartment within a duplex unit. Larry landlord issued a notice of termination to Tammy tenant because Larry landlord wants to move back into the unit with his family. True or false? Larry landlord must provide relocation assistance to Tammy tenant. And to true or false, Larry landlord may issue a notice to Tammy tenant without providing a reason in the notice. Okay, it looks like we have all the answers in. The first question is a little tricky. Well, I guess the first part. So the answer to the first question is false. It looks like most said true here. The reason that, let's see. Landlord does not need to provide relocation assistance to a Tammy tenant here is because the unit is a duplex and just cause protections only apply to triplexes and up. So that's something that we should look out for. We're advocating, well, I don't know if advocating is the word, but we're hoping that soon enough that ordinance will change and the protections will apply to duplexes as well. And so the answer to the next one, Larry landlord may issue a notice to Tammy tenant without providing a reason in the notice. This is true, and it's for the same reason. Again, this property is not covered under the TPO because it's a duplex. So the landlord may issue a notice without providing a reason in the notice. Okay, next slide. Or do you think we should take a break at this point and answer? Let me see. We just have, hold on, 2 more slides to cover and then we'll take a break. 2 more slides, I promise. So new states just cause and rent control tenant protections. So this is known as AB 1482. And under AB 1482, for covered properties, a landlord may not, it's very similar to the San Jose TPO. The landlord may not terminate the tenancy without just cause if a tenant has lived in the unit for at least 12 months. This law went into effect on January 1, 2020. Let's see. For those covered properties, again, the landlord may not terminate without just cause. Also, covered properties cannot increase rent for more than 5% plus the percentage change in the cost of living, or by 10%, whichever is higher. A tenant, may not waive their right to these protections, and any agreement to do so by the tenant will be considered void as contrary to public policy. If a unit is already covered by any local eviction or rent increase regulations, that unit remains subject to those local regulations, and this statewide law does not remove these protections or replace them. The eviction provisions only apply after all tenants have lived in the unit for 12 months or more, or where at least one tenant has occupied the unit for at least 24 months. A tenancy may not be terminated unless the landlord has one of the allowable just cause reasons, and which must be stated in the notice terminating tenancy. Let's go to the next slide, but we'll talk about the two types. Okay. So at fault means, again, where the tenant is at fault due to any one of the following reasons, very similar again to the TPO, such as non-payment of rent, a lease violation, nuisance, waste, refusal to enter into a similar lease agreement, criminal activity, assigning or subletting, refusal to allow owner enter the premises, using the premises for unlawful purposes, where the employee or agent or licensee failure to vacate after termination. This is where if the person was residing at the unit because of their employment and the employment has not been terminated and they refuse to leave, and failure to vacate after tenant provides notice. Next slide. And no fault just cause reasons mean here that the tenant is not at fault, but the landlord is still choosing to evict the tenant due to any one of the following: owner move-in, withdrawal of the residential property from the rental market, the owner complying with an order to vacate, for example, regarding habitability, intent to demolish or substantially remodel, and generally tenants are entitled to relocation assistance under no-fault evictions. And again, local ordinances may have greater relocation assistance requirements. So it's always good to look at both and make sure that tenants get what they're entitled to. And the mere expiration of a lease or rental agreement is not a just cause to terminate a tenancy. So at this point, finally, we will take a break. I think should we take the break before we take the questions? Nicole, what do you think? We're open to either way. Laura, what do you think?
We can, I think, briefly maybe spend just a few minutes answering some questions really quickly and then take a 5-minute break.
Take a break. Okay.
All right.
That's good.
Well, I guess we'll pull up the chat and look at those questions.
Yeah.
Monica, do you want to ask some of those questions to us, or?
Sure, that sounds good. I think they've sort of come in a couple of different categories. We had some about reasonable accommodations, which I think we've covered. There are some about COVID-19, which I think we're going to cover.
Right.
And then we've got some sort of more detailed questions regarding habitability. One of those was, how do you prove if the damage is caused by the tenant? For example, if a toilet keeps getting clogged, but the tenant says, I didn't do anything.
Yeah, and this generally just depends on the repair needed. So if generally the toilet keeps on getting clogged, the best thing for the tenant to do is to always notify their landlord in writing and document the issue. toilets should not, be getting clogged unless the landlord is able to show that maybe the tenant is flushing something in the toilet that's not supposed to be flushed. If other than that, there's no demonstrable proof that the tenant is causing the issue, it is the burden on the landlord to prove that the issue is caused by the tenant, especially if the tenant lets the landlord aware of what the issue that the landlord needs to repair is.
Great, thank you. I think another habitability example that we got was regarding bed bugs and whether that's included and sort of what the time frame is in terms of how long it is to reasonably address it.
Yeah, and so bed bugs are included in, the unit does need to be free of bed bugs in order for it to be habitable. Again, there's a duty upon the tenant to inform the landlord of the bed bug issue, and landlords should, address that issue quickly because it can spread to other units as well. So generally the time frame is interesting. They generally should be shorter, but there can be instances where maybe a tenant, due to their disabilities, needs more time to comply with all the instructions. Generally for pest control and bed bug situations, like making their unit compliant, so that pest control can come in and properly do any spraying or heat treatment or anything necessary for the bed bugs. And so in some circumstances, tenants can require reasonable accommodation for more time to comply with any instructions.
Great, thank you. Another question we got, and then maybe we'll take a break and review some of the earlier or the more recent questions during that break. But another one we got regarding habitability is, if the repairs take a long time, is the landlord obligated to pay for a tenant to be housed elsewhere?
Yeah, and this depends on the type of repairs needed. So for example, if a tenant can still live in the unit while the repairs are being done, then generally a landlord may not be obligated to pay for housing elsewhere. But if there's an issue where the tenant actually does need to vacate in order for the repairs to be completed, then the landlord may be obligated to house the tenant in either a hotel or a motel for the time being while the repairs can be completed.
Great, thank you. We did get one more asking if landlords are allowed to charge for repairs.
So in this case, it depends. If it's just a general repair issue that needs to be fixed, then the landlord is responsible for the cost for repairs, unless the tenant or the tenant's household substantially caused the damage. So for example, if a tenant does have a pet and is allowed to have a pet, but maybe the pet like bit something and caused some damage, then the tenant could be responsible since the tenant or the tenant's household caused the damage that further repairs to be needed. So it depends.
Great, thank you. We did get one more question about the extra bedroom reasonable accommodation requirement. Do we want to address that before or after the break?
You can ask it. Let's see what it is. If it's
sure. So the question is, if a person with a disability has a live-in caregiver and they live in a studio and they ask for an accommodation for one bedroom, so the sort of extra bedroom reasonable accommodation requirement.
So I'm going to assume that this is in the context of the person. Maybe the person is a Section 8 voucher holder, probably, and or if they are, then they would make that request to Housing Authority. They can make a request for an additional bedroom. If they have a caregiver who they have an RA for, the caregiver is entitled to have their own separate bedroom. Now, if it's just a private landlord, if the landlord has other units that are available and they want to, switch their units over to a larger space, they can make that request to the landlord, and as long as they're able to pay the additional cost for the additional bedroom, then I don't see why not. Sorry, it's baby crying in the background. Laura, if you want to add to that, please feel free.
Yeah, I mean, it is different in private housing, and it does depend on if the landlord does have an available unit or not. If the landlord doesn't have an available unit, then they can be asked to be put on the wait list as a reasonable accommodation, or be higher up on the wait list as a reasonable accommodation too.
Thank you. And so with that, we will give you the 5 minutes that we promised as a break. And so if we could have everyone return promptly at 3:34, we'll resume then. And we'll be looking at the rest of the questions that have come in and have some answers. Thank you. Punctual.
Okay. All right. So I'm going to go over the notices quickly, just because Lara touched on them earlier, and I will touch on them again. But the important thing to note is that there are different kinds of notices that a landlord can give in order to evict a tenant. The very popular ones are 3-day notice for non-payment of rent. There's a 30-day notice or a 60-day notice, depending on how long the tenant has lived in the unit. If the tenant has lived in the unit for less than a year, then they will be entitled to a 30-day notice. If they've lived there for more than a year, then they'll be entitled to a 60-day notice. 90-day notices are required for all rental properties that are under foreclosure or for tenants with Section 8 vouchers. But just keep in mind that local ordinances, again, what we discussed earlier, the Just Cause ordinances, as well as AB 1482, provide those additional protections regarding notices. Next slide. Thank you. So here's a quick preview of the eviction process. So an unlawful detainer action is a process by which a landlord can evict a tenant. A landlord cannot evict a tenant, legally evict a tenant, unless they go through this process. If they fail to go through this process, then the tenant may be able to bring an unlawful eviction action against the landlord. Excuse me. Let's go to the next slide. Okay, so in order to begin the eviction process, the landlord must serve the tenants with a written notice. Again, it could be a 3-day notice, a 30-day notice, 60-day notice, 90-day notice, depending on the nature of the eviction. And this notice must be properly served on the tenant for it to be considered a valid notice. Otherwise, the case could be dismissed. And upon expiration of the notice, the landlord can then proceed to court to file what's called an unlawful detainer action, like I just mentioned. Here, the tenant will be served with a summons and complaint, which again must be served properly for the action to be valid. And once the tenant is served with a summons and complaint, then the tenant has 5 days to file a responsive pleading, such as an answer. When an answer is filed, there's different types of defenses that could be asserted, and Lara alluded to some of those earlier. And in the packet that will be distributed following this presentation, you will see those points there. So I don't want to take so much time going over those. And just if the tenant files the answer following within those 5 days, then what happens is the landlord will then make a request to the court to set the case for trial. Trial is usually set within 21 days of the landlord's request, and the tenant is entitled to request a jury trial. Generally, where judgment is granted for the tenant could get to stay in the unit. However, where judgment is granted for the landlord, then a writ is issued and a sheriff with a sheriff's notice can go and post that notice on the tenant's door. And once a notice is posted by the sheriff, the tenant generally has 5 days to move out of the premises. Now, on the other hand, where no answer is filed or no response is filed by the tenant within those 5 days, then the landlord could request a default. Sorry, just give me 1 second. I'm just going to put myself on mute so I can give them the clear. Okay, bye. Okay, sorry about that. For whoever wanted to see the babies, I hope you saw them. They're very entertaining. Okay, so if the tenant doesn't file a response, then the landlord can go after 5 days to request a default judgment. And once default is entered, it would be exactly the same process as if the tenant had lost at trial. And again, after getting the sheriff's notice, the tenant would have 5 days to vacate. However, the tenant could request what's called a stay from the court for up to 40 days. But the tenant must be able to make payment for any number of days, up to 40 days that the tenant requests, and that payment has to be made upfront to the court in order for that request to be granted. And there are other post-judgment relief motions that could be filed, but this is just generally, I guess, a general overview of the process from when they first get a notice to judgment. And also, usually a lot of cases are settled before they go to trial. And if the case is settled, the parties can enter into what's called a stipulated agreement. And the stipulation can take various forms, and it can address certain concerns. For example, if the tenant would like to stay, the stip can provide that the tenant will pay back the rent that was owed. But if the tenant fails to make that payment, when it becomes due, then judgment will be entered in favor of the landlord and don't have to go. Okay, next slide. Here is a hypo. Tammy tenant who has a Section 8 voucher moved into the unit on July 1st, 2018. Tammy tenant's lease expired on July 30th, 2019. But landlord continued to accept rent from Tammy tenant. Just pay attention to this date. On December 30th, 2019, Larry landlord issued a 30-day notice to vacate the unit. Question, true or false? Larry landlord issued a valid notice to Tammy tenant. 2, if false, how much notice should Tammy tenant have received? And then 3, suppose Tammy tenant does not receive a Section 8 voucher. How much notice should she have received? There's a lot to unpack, but hopefully. Okay, let's go over the answers. Sorry, this is kind of like a law school exam question here. So the It looks like most people said false to the first one, which is correct. Let me pull up the question again. Our landlord issued a valid notice to Tammy Tenant. The answer is false. And I'll go over the reasons in a bit. The second one here, Tammy Tenant, if false, how much notice should Tammy Tenant have received? Most people said, looks like we have 49% said 90-day notice, 26% said 60-day notice, and another 26% said Tammy got the correct notice. The answer there is she should have received a 90-day notice. And again, I'll go over the reasons in a bit. And the third one is, the answer is Tammy should have received a 60-day notice here because she doesn't receive, suppose Tammy does not receive a Section 8 voucher, how much notice she should have received? Okay, let me just unpack this whole thing, okay? Want to look at the dates, right? So Tammy, first of all, she's a Section 8 voucher holder, and she's lived there for over a year. But the landlord only issued a 30-day notice. Because she's lived there for more than a year, that notice was not valid, okay? And then, and that's why she should, and so in number 2, because she gets a Section 8 voucher, Section 8 voucher holders are entitled to that 90-day notice. So that's why she should have gotten a 90-day notice. Now take that out. If she doesn't get, if she's not a Section 8 voucher holder, but she has still lived there for longer than a year, right? So she should be entitled to a 60-day notice. So there's, you know, I know again, there's all these points there, but just it's good to know these nuances and be able to hold the landlords accountable and make sure that the tenants are getting the right amount of notice that they're entitled to. Okay, next slide.
Okay, so now go over eviction moratorium and tenant protections related to COVID-19. Try to get through this quickly. There is a lot of information in here, but here's just a quick snapshot of the various levels of the different protections enacted at the various levels of government. So at the federal level, we have the CARES Act that was passed by Congress. At the state level, we have the governor's various executive orders, as well as the Judicial Council rules, emergency rules that relate to evictions. Legislators currently voting on a new tenant protection bill related to COVID-19 that could go into effect as soon as the governor signs it because it's an urgency bill. We'll briefly talk about that. The Santa Clara County eviction moratorium, as well as various city eviction moratoria. Next slide, please. So the CARES Act, it was passed March 27th of this year. It set in place a moratorium which provides the following protections for 120 days. So this eviction moratorium applies to federal housing programs that are generally covered under VAWA. This includes HUD programs, including some Department of Agriculture programs and rural housing voucher programs. The main programs that are covered are definitely Section 8 voucher holders, Project Relief Section 8 units, and low-income housing tax credit units, which are some of the kind of most popular housing subsidized programs in Santa Clara County. The eviction moratorium provided that tenants couldn't be evicted for that 120 days after it was passed. This has since expired July 25th. So during that time, tenants couldn't be evicted for not paying rent. Tenants cannot be charged for any late fees due to non-payment of rent, and after the moratorium expires, which has expired, tenants are entitled to a 30-day notice. So even though the eviction moratorium has expired, this 30-day notice requirement is still in effect, and landlords must provide 30-day notice to those that are covered under the CARES Act. So generally, landlords can provide a 3-day notice to pay rent or quit. That is not allowed anymore, and these tenants that are covered under the CARES Act are entitled to a 30-day notice. And this provision of the 30-day notice doesn't have a sunset provision, so this 30-day notice arguably is in effect until they say that it's not. Again, tenants are still responsible for owing any back rent. And again, the moratorium just applies to certain federal housing programs. It does also provide that there's multifamily buildings where they have 5 or more units. If buildings are able to have forbearance protection due to mortgages, while forbearance is in effect, a landlord cannot initiate an unlawful detainer or eviction action, or even serve a tenant with a non-payment of rent notice while the forbearance is in effect. Next slide, please. So there's the Judicial Council Emergency Rules on Evictions. This was enacted as of April 6th of 2020. It actually expires tomorrow, September 1st, 2020. This rule, this emergency rule on evictions, prohibited courts from issuing a summons and complaint for any eviction actions that were filed. So in Santa Clara County, the Superior Court did not accept any new eviction filings unless it did meet the limited exception where the eviction was necessary for public health and safety. Unfortunately, this rule does expire tomorrow, so come September 2nd, landlords can begin to file eviction actions, and the courts will accept eviction actions. The governor has issued various executive orders. The latest executive order basically allowed local governments to continue to have their eviction moratoriums in effect until September 30th. Currently, Santa Clara County did extend their eviction moratorium until the later of whenever the governor's order expires, which is currently September 30th or November 30th. So right now, as we'll discuss later, the Santa Clara County eviction moratorium will expire September 30th unless extended further by the governor's executive order. And then currently over on Friday, bill was language in Bill AB 3088 was finalized. It's currently being voted on, as I know of, and it's an urgency bill that requires 2/3 vote in the legislature. If passed, it won't be enacted unless the governor signs it. It seems like this will go through. There's very important provisions in this related to COVID to protect tenants who do have non-payment of rent as a result of COVID hardship. Some important points in this bill include that notices for non-payment of rent, we discussed earlier, were generally 3-day notices. Under the CARES Act, it's 30-day notices, and now in California, it'll be 15 days. So a lot of changing parts and a lot of different notice timelines to be aware of, but the bill includes language that the notice period will have to be 15 days instead of 3 days. Then a tenant can provide low-income tenants can provide a self-declaration related to COVID hardship. The landlords will generally provide the declaration, what needs to be included in the declaration. Higher income tenants will have to demonstrate actual documentation. So, and lower income tenants can just provide a self-declaration, but higher income tenants, which is about 130% of the median income, will have to provide actual documentation demonstrating their COVID-related hardship. Other important things in the bill is that the debt related to any unpaid rent will convert to a consumer debt, and so this means that tenants cannot be evicted for this non-payment of rent, but they still owe this amount, and landlords can file a small claims action to recoup the balance or go to collections for any unpaid rent. Another quick, something that's in the bill is that there's increased penalties for illegal lockouts and utility shutoffs. So a landlord can't, if they can't go through the lawful way, like BC described earlier, going to the courts and obtaining a judgment to evict a tenant, they can't simply change the locks or shut off the utilities. There are increased penalties for a landlord who does engage in that behavior, and a tenant can file a small claims action for any utility shutoff or illegal lockout. Next slide.
Okay, so the next slide is on the Santa Clara County eviction moratorium. And then we'll also go over a breakdown of different city eviction moratoria and the protections that they offer. So on March 24, 2020, the Board of Supervisors of the County of Santa Clara adopted an ordinance that temporarily bans the eviction of certain residential and commercial tenants in Santa Clara County who suffered substantial loss of income or substantial out-of-pocket medical costs because of COVID-19 pandemic. This ordinance was enacted to prevent tenants from homelessness or housing insecurity during the shelter-in-place order, and it prevents residential tenants who have experienced loss of income due to COVID-19 related impacts from being evicted. So who's covered? Tenants who have lost, again, substantial income or had out-of-pocket medical costs because of COVID-19 or the public health response. And the protections, what are the protections? So covered tenants cannot be evicted for non-payment of rent or for any no-fault reason. Excuse me, like Lara mentioned, there's all these expiration dates. So here it's until the expiration of the governor's executive order, which is September 30th, 2020, or November 30th, 2020, whichever is sooner. I'm not going to go over no fault reasons here, just because we've gone over most of them earlier. So when do tenants have to pay back their rent? So tenants who stop paying rent during this time must pay back 50% within 6 months of the end of the moratorium, and the full balance must be paid within 1 year of the end of the moratorium. And landlords cannot charge or collect any interest or late fees for any rent that is deferred as a result of this pandemic. To be afforded protections, tenants must notify the landlord that they have been financially impacted by COVID-19 and provide documentation before any judgment of eviction is executed. Next slide, please. So here's a breakdown of the different city eviction moratoria and protections that they provide to residents of each city. It's important to note that tenants in these cities are also covered by the Santa Clara order, which I just discussed in the last slide. And tenants enjoy the benefits of whichever order provides the most protections to them. So for San Jose only protects tenants who have lost substantial income due to COVID, and not tenants who only have COVID-related medical bills. Okay, so it protects both, I should say, sorry, worded that funny. And then tenants must notify their landlords again that they have been affected by COVID-19. And here, in this case, they must notify them within 7 days of receiving the termination notice. Those timelines are really important in order to be able to assert these defenses in case there's an eviction case. The moratorium, which was previously set to expire on August 31st, has now been extended to here, San Jose. It's kind of weird the way the expiration date, where it falls, but it's currently set to October 17, or it may be extended. Let's just put it that way. Landlords may not charge late fees or interest rates, and rent is due. So tenants have a whole year from the expiration of the moratorium to pay back all of the rent, but again, 50% in San Jose must be paid within 6 months of the end of the moratorium. And Palo Alto is similar to San Jose. Under this ordinance, it only protects tenants who have lost substantial income due to COVID-19, and not tenants who only have COVID-related medical bills. Tenants must provide proof that they were affected before the notice of termination expires. Under this moratorium, landlords may not charge late fees or interest rates, and Palo Alto tenants have up to 120 days or 4 months following the expiration of their state emergency to pay any deferred rent. And again, for all of these moratoria, in order to take advantage of this protection, tenants must notify their landlords that they have lost income from COVID before the expiration of the notice. It's always best to do so in writing. Next slide, please.
Yeah, and so we also have listed in this chart Mountain View and Sunnyvale. I know we're running out of time, but quickly just some quick things for Mountain View. The moratorium expires November 30th. For Sunnyvale, it's 180 days after Sunnyvale ends their state of emergency. They both have tenants have 180 days after the ordinance expires to pay back the rent. And again, there's different ways that there's different obligations upon a tenant in order to take advantage of these protections. So they do have to provide notice of and document their inability to pay rent due to COVID. For Mountain View, they need to provide notice when they can't pay 7 days after the rent is due, and provide documentation within those 14 days after rent is due. And then in Sunnyvale, they have to provide written notice of inability to pay rent 30 days after rent is due. Next slide. So what should you do? What should a tenant do if they are served with a notice they are unable to pay rent due to COVID? They should immediately inform their landlord. Santa Clara County has a notice that is fillable that tenants can provide. We are also submitting, we have materials that also where a tenant can provide their landlord and assert their protections under Santa Clara County's moratorium, and also whether or not the landlord complied. There's some additional check boxes, so you'll receive that as part of the materials after this presentation.
Okay, just quick points here. Landlords are not allowed to conduct self-help evictions. They may not change locks or block a tenant from gaining reasonable access to their home with the intent of terminating the tenancy. They may not shut off utilities with the intent of terminating tenancy. And if they do any of this, they may be liable for both civil and criminal penalties. Yeah, I think we made it to the end.
I want to be mindful of time. Thank you so much for staying on, for those of you who were able to stay on for the entirety. I know there was a lot of content that was covered. So again, we will be sending out an email with the slides and additional resources. And we were hoping to conclude with a last Q&A session, but we're saving all the questions that were in the chat. So we'll pull together an FAQ document to send that along. I don't want to keep you any longer, but you can expect a feedback form shortly. And I'd really appreciate if you fill it out, because I do read through every single response, and we incorporate that into our trainings for the future. So thank you very much, and enjoy the rest of your day.
Thank you, everyone.
Thank you, everyone. Bye.